For those of you that are like hyper competitive, you can use your real names. But for those of you that just want to see here and learn, you don't have to use your real name in a Kahoot game.
Are you saying that I should pick a nickname?
I'm saying, actually, based on our conversation earlier in the week, you should be anonymous. Okay. Maybe you should go, I'm just joking. I'm only joking.
There. Let's see.
Lisa, are you going to share with us or are you just teasing us?
I am working on it. Here you come. It should be there. Can everybody see that?
And how much time did you give them this time? Their biggest complaint last time, they blamed you, actually. They
I
said,
gave them less time because they complained at half 30 this time.
so we tried to do a couple of things. One, I think most answers, most questions are shorter. Don't you think so, Lise? And then we
I don't
also
know, you
gave,
wrote them.
what, 10 more seconds?
Yeah.
Okay.
Yeah, we did 30.
But there's no reason we can't stop and talk about the question afterwards. I don't think there's a time constraint on that. Okay. So I still think this is get her done. That sounds like something Sheldon would say. Did he join? Get her done.
I don't think so. Let's see, we got 1, 2, 3, 4. Is everybody in who wants to be in?
It says there's 5 people.
I don't think I'm in yet because I keep getting texts at the same time. It just still says connecting.
Okay. Okay. So 1, 2, 3,
I'll
4.
just play on paper if I can't get in.
No,
No,
well,
see,
wait a minute.
she doesn't want her score in there. Now we're gonna know who Charlotte is.
I can't even like exit out. Let me try. There, yeah. My kid, I got all the browsers open. Like kids make fun of me.
Now I don't know if it'll help you guys or not, but in after May 1st, we're actually going to start. How long does your class go? You might know how long this class goes.
Like the 22nd, I think is the last day.
Okay. Starting in May, because we're going to start a night class next week, we actually will also be doing this on Monday nights for 2 hours. So if you want to see it twice, or if that worked out better for your schedule, or whatever, it'll still be relatively small groups to start with as we're trying to build our audience. Can I start the game yet? Or
Yeah, I'll start it. You ready?
okay, go ahead. And we are off. I can't wait to hear the music. That's what I always like about Kahoot. Can you read the questions, Lisa? I can't see them. Remember, we're not going to read the answers, though.
What is an unlawful intrusion from one property into another? I thought they had to read it last week because they liked that better.
Okay. All right. They're looking strong so far. My screen's not working out very well right now, so I'm having a hard time seeing.
We got 5 on encroachment, 1 on easement, and 1 on emblement.
Okay. And this is, of course, I mentioned to you last week the idea of the E words. Every word that you see on there is an important word. Encroachment clearly is the answer. Look, you're going to get tested on easement, so make sure that you know easement hands down. And then the words Estover. What's the other E word? Is it a sheet? I can't see it on my screen.
Emblement.
Emblements. Those are level 1 vocabulary words. So emblements are just crops in the field or the right to retain the crops if you sell the property. Estovers, of course. Another thing that you can do, make sure you make sure you can associate it with the topic. So the biggest thing that I would want you to remember about Estovers is that it goes with life tenancy. And if it goes with life tenancy, what does it mean? Estovers means you can use the property to prepare the property. So with a life tenancy, for example, you can cut down the trees to repair the house. You can't cut down the trees if you have a life tenancy to sell them for profit because a life tenant cannot reduce the value of the property. So, and again, any of these things that you need clarification on, I'll be glad. But the E words, vocabulary words, get them right. Did well to start with. Keep going. Where's the music, Lisa?
I don't know. All right, you ready?
And now we know who Get Her Done is. It's obviously Bree because Bree's got the quick fingers. Oh, it wasn't Bree this time. All right, keep going.
I'm not seeing the actual question or answers. I'm just seeing like a triangle, circle, diamond, and square. I don't
That's
know if
what you can see on your device. If you look at your screen, you should see your Zoom,
Oh, okay.
and look at your phone for the answer.
Okay, sorry.
Your answer. That's okay. I'm sorry. I should have asked if anybody was unfamiliar with Kahoot. That's my bad.
Okay.
All right, everybody got that one good. And the trick there was title search. We were trying to get you to think that encroachments coming in title searches. They absolutely, I do not. I'm not going to speak too long on it because you all got it correct. Lisa, there's two things I don't like about this. I would like for you to read the questions, and then I would also, I miss the background music. It's the silence is disconcerting.
I can hear it on my end.
Okay, so it's completely
Anybody
me.
else hear it?
If
I
it's
don't
just,
hear it. I think when you share your screen, you have to check that box that said that you want everyone else to hear it. I haven't used Zoom in so long, but I remember back in the day when I would do presentations.
I'll try that next week. Sorry.
okay.
I
All
can
right.
hum if you want me to hum. So I'm not reading the question, or I am reading the question.
Please read the question. It kind of gets the flow. We
Silence.
didn't read
Okay, here we
the
go.
we didn't read the answers last week because they wanted time to think.
All right, here we go. Which of the following is a private restriction on land use?
Can I undo my answer?
I'm going to pat myself on the back on this one. This is a great question. You don't realize how great a question this is. So I'll tell you, okay? Notice that everyone on there is a land use restriction, right? And so the question becomes, which one is a private restriction, which y'all did really well. What's the yellow answer? I can't see it on my screen, Lisa.
Zoning.
What's that?
Zoning.
Coding?
Zoning.
And zoning. So the idea here is that there are public restrictions and private restrictions. Restrictive covenants are completely private. That's your neighborhood. That's not the government. The one I thought I would get you on, you didn't answer. So Nicole has taught you well. The word subdivision ordinances has subdivision in it. And some people think, well, that's private then, right? But an ordinance is always public law. So that's how you could rule that one out. Y'all did fantastic. Good job.
All right. Ooh. In the event of a conflict between a restrictive covenant and a zoning ordinance, which will control? Woohoo! You got him this time, baby.
Oh, I did get him a little bit. I did get him a little bit. The correct answer, again, I can't see it on my screen, but what
Most
is
restrictive.
it should say the most restrictive. Okay. The idea behind this, and by the way, this is actually going to be the case on any type of laws. When you get to the Fair Housing Act, for example, there's a state Fair Housing Act and there's a federal Fair Housing Act. Whichever is the most restrictive is the one that would rule. In other words, restrictive covenants might be less restrictive, but they're not going to get you out of the law. The law sometimes might be less restrictive. In other words, the law doesn't care if you build an outbuilding in your backyard, but the restrictive covenants might. So simple answer on that is always the one that is the most restrictive. Very good.
All right. Get her done. It's still in the lead. Aaron's coming up there in fourth place. Woo, way to go, Aaron.
Oh, I know what I could do. I can change my screen view. That's what I'm going to do.
Yes. Restrictive covenants may be enforced by all of the following except.
All right. I think they did well. I only got a couple of restrictive covenants may be enforced by all the following. This was an except. And so all of you knew that the zoning enforcement officer could not do that. The courts are a little bit tricky because people are like, why in the world would I use the courts for a restrictive covenant? Well, think about this. If I try to make a case that you're breaking the restrictive covenants and you won't stop it, I could actually go to court in essence, a lawsuit against you to get you to stop because you're breaking the contract, which is the restrictive covenant. So that tricks up a lot of people. And then any individual member of this restrictive covenants, I always say that there's the developer who created the covenants. There's the HOA, which would be ideal, to be completely honest with you. But the fact of the matter is any individual homeowner who's held accountable to the same covenants can enforce against the other. Now, it might be difficult, but it's a test question. Okay. So correct. It is a test question. One more thing. I saw this on a test a while back, and I don't know if I reflected this in my notes or not, or if Matt did in his notes, but I live in a covenant with 900 homes in it. I live in a neighborhood with 900 homes. We have restrictive covenants. Some of the houses are 2 miles from my house. They just happen to be in the same subdivision. If I'm walking by a house 2 miles away from my house and the dog's barking and he's chained to a tree in the backyard, I can enforce against them. You may say, well, why does that bother you, Chris? You're 2 miles away. It doesn't, but it's in violation of the same covenants that I'm held to. That's why I can enforce. That's why any individual homeowner can enforce. Okay, keep going, Lisa. This
They
is
don't
fun.
tick off your neighbors. That's what he's saying.
True.
All right. Now on to the next one. Which of the following is not true regarding the Machinery Act? Why are you chuckling?
They're slower answering this time. This one ramped it up a little bit. They're dealing with two things in their mind simultaneously. And so sometimes it's a little bit harder to process here. First of all, I don't know if it came to your mind immediately, but the Machinery Act deals with taxes in the state of North Carolina. You're taxed on a local basis, but the Machinery Act is the state law that tells you the rules for tax collections. And so then the other thing was the not. So you're looking for the one that is not true, which, by the way, when you're actually taking the test, and you're not going to see not questions anyway, but I would still use this strategy. As I'm reading an answer, I'm just writing beside each one of them, whether I think in and of itself it's true or false. To be quite honest with you, if you have 3 truths and a false, you know that has to be the answer. So which is not part of the Machinery Act. Real property must be valued every 4 years is, I'm sorry, that's not the, okay, that's right. We're looking for the not. Every 8 years is the rule. It must be reevaluated for tax purposes every 8 years. The other of those are true statements. Your tax rate can change every year. That's just a simple meeting of the county commissioners or the city council to do that. Real property taxes are always due September 1st. Look, nobody pays them September 1st, but they're always due September 1st. Nobody pays them September 1st because there's not a penalty until January 5th of the following year. And then finally, properties are taxed on an ad valorem basis. If you haven't already done it in your notes, make sure you know what ad valorem means. It just simply means according to the value, we are taxed on an ad valorem basis. Okay.
Woo, Nadia's moving up. Which of the following liens has the highest priority in the event of the foreclosure sale?
Okay, most of you did well on that. We tricked a couple of people about the state and the federal tax liens. The state and federal tax liens, they actually are prioritized based on the time that they are recorded. So the fact of the matter is they typically are going to be less than your real property taxes, which always jump to the front. Your state tax lien might jump your mortgage, but it's not going to jump real property taxes. And if you think about this, the logic behind real property taxes is that the state just collects theirs off the top. Is what, not the state, the municipality collects theirs off the top. By the way, if I wanted to add one more trick to this, although real property taxes are the highest priority lien, There is one thing that is paid at a foreclosure sale before the real property taxes. Does anybody know what it is? You know what's paid before real property taxes at the foreclosure sale?
Would it be a mechanics line?
Nope, nothing can jump real property. Let me rephrase that. No lien can jump real property taxes.
Okay.
Good guess, though. Good guess.
Would it be the
Mechanics lien.
mortgage or,
No, no.
no, because that's a private loan, yeah.
A real
It's a-
estate agent.
Say again, the real estate agent. It should be. And actually, that's the closest. Let me go ahead and tell you. It's the cost of the sale. It's the attorneys. Okay. And if you think about it, they don't put a lien on the property. What they say is, we'll handle the foreclosure sale. We'll pay the cost of court, but we have to be paid back first because we're getting nothing out of this. So the first thing that is paid at a foreclosure sale are the costs of the sale. The first lien that is paid is always real property taxes. Slam dunk. I mean, those are the only two questions that could come up on that.
Whoop, Aaron's moving up.
Mhm.
Which of the following would most likely be paid for by a special assessment?
This is another great question by today. I must have been on fire when I was writing these. These are all awesome for teaching purposes. Clearly, the answer is obviously A. You see that there. Here's the idea behind this question. Some things are paid with your real property taxes. Some things are special assessments. Your real property taxes tend to be ongoing costs. The police, the fire, municipal building, schools, et cetera, et cetera. And then the special assessments are one-time improvements. And the only people that pay them are the ones that benefit. If I wanted to add one more piece of information to that, I would say you're often assessed on that based on your proximity to the improvement. So in other words, if it's a water line, if you have a wider lot than the guy next to you, your assessment is more because oftentimes they evaluate it based on the width of the lot. Okay. So again, 2 or 3 important points to remember there. The key important point is the difference between special assessments and your real property taxes, what they pay for.
All right, moving on. Number 9. Which of the following is the right of the government to take real property for public use?
Okay, eminent domain, of course, is the answer there. And some of you fell for the trick. In any question where the answer is eminent domain, the one of the other answer options is going to be condemnation, so that you distinguish in your mind the difference between the government's right to take real property versus the actual act. Condemnation is the act of taking the property. Eminent domain is a vocabulary word that describes the right of the government to do so. I don't think any of you guessed the, oh, there was one more. Oh, escheat. Escheat is, it is a power of the government, but in escheat, they're not taking the property. The escheat is when it is being left to the government because you had no other heirs. You died without a valid will and without any heirs. So that was a good guess on escheat. But the government's not taking the property. The government's basically inheriting the property because there are no other heirs.
Woo, look at Nadia moving to the top. Woohoo!
Dang, she's a slow starter, but she jumped up there, didn't she?
She did. The rights of the government and private property include all of the following except
Okay, good job on that. And there's two ways you're studying for this, and y'all did well, so I won't spend a ton of time on it. One is to remember your acronym. I don't know if y'all use this in class, but PEAT, the rights of the government and real property, police power, eminent domain, taxation, and escheat. And notice the dirty thing I did on this is I use that same pattern. Exclusive use does go on a list, but exclusive use goes on the deep sea list. What are the rights of homeowners? I have the right to exclusive use of a property. So y'all did well on that one. Good job.
Woo! All right, on we go. Number 11. A slight deviation from the zoning ordinance made necessary by a unique hardship is.
Okay, most of you got variance there, which is good. I do like this little section right here, definition. Make sure you understand your definitions, and then you have to kind of separate. I will tell you that for exam purposes, the most common wrong answer is spot zoning. The difference between a variance and spot zoning is in variance, I'm not asking the municipality to change the zoning ordinance. All I'm asking is for a slight deviation because I have an odd shaped lot or something like that. In spot zoning, you're actually asking for a change of our zoning, but none of you guessed that. So you're in good shape. And I say, I kind of got one person with the zoning change. And by virtue of the fact that I haven't been your instructor, you miss my jokes. So I'll go ahead and get one of my jokes in right here. Lisa, you will need to play my straight man on this since this is not live. And then,
Okay.
do you know how you catch a unique rabbit?
How?
Unique up on him.
Bah!
That's
Y'all
good
should
stuff right
spend
there.
all day with him, okay?
Do you know how you catch a tame rabbit?
No, how do you catch a tame rabbit?
Tame way, stupid. That's good stuff right
You
there.
watched too many Warner Brothers cartoons growing up.
You can't get that for free anywhere else.
All right, moving on. All right, Bree is moving up. Nadia is still in the lead. A small office building remains in an area that was recently zoned residential. This is an example of an,
Oh, shoot, I messed up.
well, you wrote it, not me. Are you messing with them? Is that what it is?
No, it's the answer is obvious. Oh, the answer wasn't obvious. Go back and make a note to put that as a or an. I should have put the in parentheses there. Okay. But having said that, non-conforming is correct. Why is that correct? It's correct because the building was there first and then the zoning changed. Okay. The building was there first, then the zoning changed. If the zoning had changed and then they put a commercial building there, obviously that would have been the illegal use. Conditional use and special use kind of go together, and special use focus on that definition because special use is something that they do test you on a lot. Conditional use is a little bit weird, but in regards to special use, the definition of a special use is something that's different from the zoning ordinance because it was anticipated. For example, if you think about where most schools are in residential areas. And you say, well, the school's not residential. How did it get there? It got there through a special use permit because it benefited the zoned area. But anyway, the correct answer there was non-conforming use.
Get her done, moving back up.
I think we only have three more questions left.
Uh-huh. Which type of legal description describes the outer perimeter of a property?
All right, and that is a meets and bounds description. I saw this on a test one time, and it hurt my head to start with, and then I thought about it, and I said, "Oh, that's exactly what meets and bounds does." All meets and bounds does is tells you where the corners and the lines of this property are. So in essence, it describes the outer perimeter of the property. So that was in fact true. Got a couple of you with rectangular survey system, and rectangular survey system has a few bullet points that we need you to understand in regards to the rectangular survey system. First of all, it's not used in North Carolina. Okay. And then you have to understand words like township and section and 640 and 43,560. And I don't know, there might be some other ones as well. But anyway, the meets and bounds is what we described there. Do we only have 6 people playing, Lisa?
Mhm.
Okay.
Oh,
When
look
the,
at Roger's on the stand. Woohoo! There he goes. I see him.
when you see 6 answers, you can go ahead and skip. I thought it automatically did that, but it doesn't.
What is the most likely legal description used in an urban area? Actually, there's 7.
Is there? Okay. Oh, okay. Kind of got you all over the place on this. So let me tell you what the couple of key topics were here. Matter of fact, only one got the right answer. So that'll be a separator for you. In an urban area, first of all, you have to know what an urban area is. Would you agree that an urban area is more like a city as opposed to rural, urban versus rural? I started to use the word suburban because that would apply as well. In an urban area, everything has been platted. You know exactly what the lots are because they are all on a plat that's registered at the Register of Deeds. Okay, so everything is defined by where it sits on that plat, just like a subdivision. Okay, so that's the answer. Reference to a recorded deed. You typically see these in rural areas where a deed has been passed on over time, but nobody has gone out necessarily and put a meets and bounds description on it. There will be one, but it might be an antiquated meets and bounds description. Government rectangle survey, not a bad guess, by the way, but that would apply in certain states. And again, that's going to break down to your township sections, et cetera, et cetera. And then meets and bounds would be meets and bounds will be more likely in a rural area as well. Kind of goes along with the concept of a survey, but reference to a recorded plat, the plat was there. You can put your finger on the legal description of a property on the plat.
Woohoo, here we go.
Moving up. All
The
right.
last one.
Last one is going to get close.
Which of the following statements is true regarding the government survey system?
Oh, there's a mistake on this one, Lisa.
Sorry, I just copied and pasted. Are you gonna tell them what it is?
No, actually, no. I'm sorry. It's not a mistake after all. It's fine. Okay. The correct answer in this case is there are 36 sections in a townhouse, which is a true fact, a township, which most of you got correct. When I look at A, I notice I use 640 because that is a relevant number in the government rectangle survey system. There are 640 acres in a section, okay, not 640 square miles. So anyway, that was the trick there. Schools are historically located in section 1. They're in section 16. That's where they are. And then the east-west lines are known as meridians. No, meridians run north-south, baselines run east-west. Okay. And why did I ask these? I gotta be honest with you. At the end of the day, that's about all you need to know about the government rectangle survey system. So we might ask it in different ways, but you just need to know the numbers involved. You're not going to have a math test question about the rectangular survey system, otherwise known as the government survey system. All right, so wrap them up for us, Lisa.
Bum, bum, bum.
Coming in at third. Amen. See, now you can tell who you are now that you know that you're on the podium.
Get her done is 2, and number
You're
1.
done, and then it's Nadia, right?
Yeah.
Yay, congratulations. Congratulations.
And
Tell them what
Roger
they win.
3.
Tell
All
them what they
right.
win for their. We need to start giving prizes for this, Lisa. If they're going to go through all this work, we need to give prizes.
Okay.
All right. How do you feel after going through those questions? Does it help clarify the type of questions that you're going to get in that particular unit? What is it about that unit that scared you? Run with any of those.
Timing pressure.
Finding what? I'm sorry.
This time you guys are okay because you give me more time for me.
A little more time. A little more time. You did well. Good.
And I make some mistakes in regard to the vocabulary. For example, encroachment and encumbrance. It's so easy. I know what that means, but I make a mistake because it was pressure.
Yeah, the one thing I do want to keep pressure on you at some points is simply because going into the test, you're like, man, that's 140 questions, and I only have 4.5 hours to do it in. And you start doing the math on that, and you're like, I got to finish these questions so quickly. If you get used to answering under pressure, what you actually find out is most people finish the test much quicker than what they think they are going to. The national test questions that I'm seeing tend to be very pithy the way the ones that we saw today were. So I do want you to relax, but there will be some stress when you go to take the test. A lot of it will be stress you put on yourself. That's not necessarily the purpose of the test. Okay. What else? What else is on your minds?
This is just the hardest one for me. Like when going through it, and I need to go back and keep reviewing the vocabulary. I don't know what it is. It's not
Can
connected.
you give me an example of a word or concept that you struggled with?
I guess if I study more, I can get it right. But the meets and bounds and governmental rectangular survey system, like some of those things came out, and I was trying to remember what was tied to them. It's mostly
Okay.
vocab. Like it's on me. I spent a lot of time on the other unit, but this one was the one that I think I didn't spend as much time.
Okay, and then what I would say on that, there's a couple of things that you brought up, vocabulary, obviously, but the association is the big thing. What word goes with what? Like with meets and bounds, I'm looking for words like point of beginning, the markers, it must close. So it's almost like the words themselves are not hard. Just they associate with this. And then with the rectangle survey system, there's townships and sections and baselines and meridians and 640. And, once you kind of put those together, even the physical action of putting them together, you may only have to study at one time. They're both level 1 topics, Okay. So don't let that stress you. Easy for me to say, right? I already have my license.
stress.
What else? Were there any other topics there? Lisa, what's the other part of our agenda? Are you going to play the agency questions?
What other questions did we have? That was all I thought.
Well, you told me that we had a whole Kahoot on agency questions.
Well, we haven't. We have one from a previous class. Do you want me to play that one? Do y'all want to play that one? I don't remember what's in it. I didn't look at it since you gave me these. We can play
Okay.
it.
So go ahead. Ashley, are you saying yes to that question, or do you have another question?
Yes, and yes to playing the other Kahoot. And then also, can I just make a request to not read out loud the question? It makes it really hard for my brain to process.
Okay. I, on the other hand, I can't deal with silence, so I will walk away every time a
Well,
question.
then you're going to have to twiddle your thumbs or something because
How about the background music? Is the background music okay? Can we play the background music?
Yeah,
I
it's
see.
just the trying to process words visually and auditory at the same time is
Well, not to
at a
mention, you
different
got to look at your
speeds.
device too, because you got to look at your device to do whatever you're doing.
right.
I hear you.
All right, I'll let y'all rule. We will do it that way.
All right,
And
I'm
you can
gonna
like
try this
whistle
one.
or something, just not the same words.
All right, I'm going to try this one. I can't remember what's in it, so play along.
Lisa, as you're trying that one, you may want to make sure that it's set for 30 or 45 seconds, because since they are agency questions, then they may take just a little bit
It may
longer.
be shorter because I hadn't looked at it.
Okay.
So
Well, let's talk about it. Let's talk about them at the end of each question. How about
yeah, we'll
that?
talk at the end of each question. How about that?
Give us 30 minutes for each question.
Let's see. Give me a second here. I'm trying to figure this one out.
I am also putting in a listing while we're doing this, so of course it's fine. Multitask.
If you're putting a listing in now, it'll be sold by this afternoon.
Chris, I do have one question.
Yeah.
So I feel like I sometimes get tripped up on questions like when you were asking about what's the legal description in an urban area, most likely legal description in an urban area. So I immediately went to either it has to be a government survey or meets and bounds because those are legal descriptions. But so a reference to a recorded plat, is that also considered a legal description?
Absolutely, absolutely.
Okay.
And Aaron, where are you? You're in North Carolina, right? Or are you getting
Yeah.
your license to come to North Carolina?
I'm down in Pinehurst, Moore County.
Okay. Yeah, what you'll see once you start once you get in the field and you start working with the offer to purchase, what we ask for are multiple things on that. We ask for your address, which the address in and of itself is not a great legal description. We'll often say don't use the address by itself because that can change. But then we will also ask you for a reference to a recorded plat. And if you have a reference to a recorded plat, in most cases, that's actually the best description because you could go to the courthouse and you could find that pretty easily. And then the problem with rural areas is a lot of times they don't even have recorded plats. And that's why you have to reference a previously recorded deed, which is also a perfectly valid legal description.
Okay.
A valid legal description being defined as the ability to narrow this down to one property. So they would absolutely be okay.
Okay, thanks. Appreciate that.
All right, is everybody in that wants to be in, or do we need another minute?
I can hear the music now. I'm happy.
I am so glad that you were happy. All right, is everybody ready to go?
Hold on before you go. We haven't seen these questions in a while. So they are agency, and I know that y'all have gotten substantially far in agency by this point. So there should be no pressure on you at this point. Play, get whatever you can out of it, and then we can spend time. Y'all were amazingly quiet at the end of the questions, so I don't know if there are any questions that y'all have. In agency, I would be shocked if you didn't have follow-up questions. Okay, so let's give it a try and let's see how it does.
All right, here we go. I have no idea what's in here. Surprise.
All right, y'all did great on that. You were, of course, remembering your acronym loads or old car. Lisa, did you make these slides?
I'm sure I did.
Okay, so whoever made them, put the old car in there because that's the acronym that we use on that. And to a customer, you don't owe them a lot, but you can't lie to them. So the difference there, customer, client, that's always going to be important. Read the questions carefully. Are we talking about someone that's under an agency relationship or someone that's not? Okay, perfect.
Once you hit the button wrong, you cannot come back because I didn't read the customer, I read the client.
Gotcha. So you're the one that was wrong. So now we know.
All right. Oh, I don't know what happened with this one. That was weird.
That's just an explainer slide.
Yeah. Oh, maybe we did an explainer slide afterwards.
Okay, well, good. I won't have to talk so much then.
All right, so we'll see what happens. All right, next.
All right, it looks like they did well on that particular one. And that's just vocabulary. So that's one of those type things when you're looking at, well, what do I study on this? Just know what universal, general, and special agent mean. Realistically, that's all you did. Y'all did fantastic on that one. If you need elaboration, let me know. Oh, look at that 1 point difference there.
Oh, that's the explainer slide, sorry.
I'm not sure we made these.
I don't know. It was in my Kahoot. I assume we made it, but it was 2 years ago.
Okay, now the idea behind this one, the greatest protection for the agent, the exclusive right to sell, just simply means that I'm going to get paid no matter how this house sells, as long as it sells within the term of my listing agreement. So again, when you're studying this and there's confusion between exclusive right to sell, exclusive agency, and open listing, just make sure you're studying the thing that is important, and it's what the protections are in the agreements. For example, in an exclusive agency agreement, you're not protected because if the seller sells it themselves, then they don't have to pay you. And then in an open listing, the only one that's going to get paid is the one who procures the buyer. So you did well on that one as well. Okay.
Woo!
Actually, apparently I don't need to explain this one because they did extraordinarily well. And of course, all I was trying to do was trick you on first substantial contact. I also threw a material fact situation in there as well, which wouldn't require first substantial contact. Material facts, everybody gets to know them anyway. So they did great. Go to the explainer slide, leave it up for a few seconds, but it looks like they're fine on that topic. Okay.
Okay.
You know, this question right here, I'm skeptical that it would come up on the exam, but the reason we always ask you this is because it's the only time that you see the word initial contact coming up. And I don't know if this will help, but I'll describe to you the history of this to see if it helps. Notice who the buyer agent is talking to in this particular case. He's talking to the listing agent. If you were to go all the way back to like the 1990s, what happened at that time is we didn't have this elaborate third-party showing service. And so what would happen is oftentimes, if I was a buyer agent, I would call the listing agent and I'd say, can I come see your home? By the way, I work for the buyer. In other words, I was sending a signal to him, don't tell me anything that you don't want my buyer to know, okay? That rule has survived all the way to today. It's kind of weird. Today, it's very possible that you would not even talk to the listing agent unless you were contemplating an offer because there's a third party that sets up the showings. And so today I may call up the listing agent and say, hey, listen, we're getting ready to make an offer on the property. By the way, I work for the agent. I work for the buyer. So, you know, proceed with caution, so to speak. So initial contact only goes when the buyer is contacting the listing agent or the seller. Okay. It's the only time you'll see it.
Whoop, Breeze moving up.
This is the part of class I taught the other day. So of course they got it right. Yes. Agency agreements.
I'm
must
sure
be
that's
written.
it.
They must have a start and an end date. They cannot be automatically renewable. They must have standard non-discrimination language, and they must have your license number on it. Fantastic. Y'all did great on that.
Whoop, here comes Aaron.
Okay, you did pretty good on that one. There's no way in the world you are not going to get tested on this based on the fact that the lawsuit that's going on. I'm sure all commissions want you to be aware of this. There are no standard commissions. There are no set fees. That doesn't change the fact that your company can have a policy. People say, well, I thought commissions were always negotiable. They are negotiable, but this is what we charge. Okay. If you don't like it, you can go somewhere else. So anyway, my company policy is not subject to antitrust laws. Shut ahead, jumping on top there. I take it y'all have studied material facts based on your answers there, so that's good. This would fall into the category of what I would say a fact that relates to the property. In other words, it's development close by. It's another question you're gonna get. I mean, this is the type thing that they should absolutely ask you on the state exam. In North Carolina, you do not have to disclose that someone was killed on the property, hanged themselves on the property. It doesn't matter. It's just not a material in North Carolina. And then the sex offender, you can choose to disclose, but you're not obligated by law or rule to disclose sex offender status in a neighborhood.
No change.
License industry will always structure for a principal client.
Yeah, it's a little bit tricky there. The key word is all, and I don't know how much Nicole's talked to you about this. Be very, very careful of all, never, always. I'm not saying it's going to be wrong all the time, but that's a red flag in and of itself that you need to read the question more closely. So you have to follow all lawful instructions of your clients. But what happens is occasionally a client will ask you to do something illegal. Sometimes they don't know. Sometimes they're just asking you to cover up a fact or something like that. You do not follow those. And that was the essence of that question.
We must have written that. It mentions real estate jail.
Yeah, apparently. Okay, as you're breaking that one down, the key word here is agent knows that the roof leaks, okay? The agent knows and doesn't say it's willful. In this case, though, he did say that the roof is fine. So he made a misrepresentation. He made a representation that turned out to be wrong, which is a misrepresentation. So willful, he had actual knowledge, misrepresentation, he lied about it. And then the other one was willful omission. But notice the last part of that that says tells the buyer it is fine. That's where it went from being an omission to a misrepresentation.
Hold on. Can you explain? Because for me, willful misrepresentation is I know I'm lying. Willful omission is I know, but I'm not telling you. Well,
Yeah.
I make a mistake on those things.
Well, and that's always the case. And Roger, the fact that you recognize that that's the problem, hopefully will help you be cautious. So when I go back to this question and I look at it, and it says, but he tells the buyer that it's fine, tells the buyer that the roof is fine. That's where he made a representation.
Okay.
Okay.
Yeah,
That's always,
It's
that's
not
always.
fair. Those things are very complex. Okay.
Yeah, they try, they can't get super specific about this because material facts, it's either material fact or it's not. They can't give you gray area, but I tell you, they'll often in the question, the agent didn't say anything, but if the agent did say something, it's going to be a misrepresentation versus omission. Here's the good news about it, Roger. From a language standpoint, it might be a little bit complicated, but from a red flag standpoint, that's exactly the way they ask the question. So at least your mind, you already know what to look for when you're breaking these questions down. Lisa, you can go. Okay, thank you. Charlotte is killing agency 10 in a row. Come on. Okay, all of you got that one right. Technically, this question is written incorrectly. The way and I hope like heck they would never ever test you on this, but the way the law is written, it actually says it must be reduced to writing no later than the offer to purchase. So I asked the commission, I'm like, well, what's the difference between that? In theory, if you start writing the offer to purchase and like, oh gosh, I forgot my agency agreement, you would have to put it in writing. So I hope like heck they won't do it. But technically speaking, the law actually says it can be reduced to writing no later than the first offer to purchase. Hopefully that won't cause you a headache on the exam. You're where you need to be on that question. We almost asked this one a little bit earlier. Yeah, it's facts related to the property, very similar to the last question. Somebody got the wrong button. I was wondering about that. I wasn't going to call it out, but I'm like, we just question. All right, go ahead and move that one up. I don't think we need the explainer slide on that one, so you just go to the next question. Okay, couple of interesting things going on here. You need to, this question is harder than actually what you think it is, okay? So in the event of a breach by the agent of their duty, how does it say? In the event of agent breach of duty, whatever. We know that we're looking to punish the agent. The North Carolina Real Estate Commission may. The commission can never fine an agent. The commission can never fine an agent. All the commission can do is reprimand, censure, suspend, or revoke. That's all the commission can ever do to an agent. Well, you say, well, that doesn't sound hard. Why is this hard? Well, somebody could sue you and take you to court. If they take you to court and they win, obviously, there might be a penalty associated with that. You could go to court and end up being put in jail if you violate a criminal statute. It won't be the real estate commission doing it. Okay. It'll be the court that does that. In a civil suit, it would be a jury that does it. It wouldn't be the commission that does it. So understand the way we could go with this question. Agent does something wrong. What could happen? Well, commission, reprimand, censure, suspend, revoke. Court system, they can have a monetary penalty. And then criminal court, they can put you in jail. You could, in theory, you could go to jail for violating licensed law. It wouldn't be the commission do it. It would be the court that did it. Roger, making a comeback. Okay, good job on that one. Buyers and sellers agents are special agents. About the only time you'll see general agency pop up is two places. Property managers. Property managers are often more general agents. You say, well, why are they general agents? It's because they're given more authority, just in a narrow area. But they're more general agents. Also, general agent would be the relationship you have with your firm. So for example, if you join my firm, then I would say, here's the deal. You can go out and list houses, you can work with buyers, et cetera, but you can't run the office. I'm giving you broad discretion, but in a very specific area. To me, I think I would just memorize that. Special agents, working with buyers and sellers, general agent, property management, and the relationship you have with your office. This is an accept question, accept. Okay, good job on that. You recognize the fact that this agent is in a multi-agent firm. So if one agent were to die, another agent could just simply step right in according to the way the agency contracts are written. And I will tell you again, death is a big thing on this test. What happens if someone dies? What happens if there's a sale? That type of stuff. And agency relationships, I would ask you, as you start moving forward and you get into contracts, keep your eyes open to the difference between what happens to an agency agreement when someone dies versus what happens to an offer to purchase contract when someone dies. That's a little bit of foreshadowing for you, but it's a great distinction for test purposes. It also would have been different if it was a single person firm. If it was only a one person firm and the agent died, then obviously the contract would die as well. The agency agreement would die. You know, as I was reading the answers there, I'm like, man, this is kind of a tough way to write these answers because I used a couple of double negatives and stuff like that in here. But then when you got to the final answer, you're like, oh, okay, it's designated agency is a type of dual agency. So as it turns out, green was correct, regardless of what the others said. And so there was two ways of answering that question. You could have backed into it, or you could have just recognized the point I was trying to make is designated agency is a type of dual agency. There you go. Okay, let me tell you where I was going with this particular question. If you have a contract between two parties, which an agency agreement is, okay, and when we get to the contract chapter, we'll talk about bilateral versus unilateral. In a bilateral contract, one party can't just wake up and decide to break the contract. It would take the mutual agreement to do it. So the point that this is trying to make, and if you missed it, by the way, it's not written as well as it should have been. But in this case, the buyer can't unilaterally terminate. The buyer can come to me and ask me if I'm interested in terminating. He's like, I don't like you, you don't like me, let's terminate the contract. That's completely fine. But one of us can't just decide one day to terminate the contract. Now, let me tell you why I wrote this and what you're looking for. Hopefully this will help. There was a test question a while back that I saw in a database that it said something to the effect of, how was it worded? The buyer has a legal right to terminate an exclusive buyer agency agreement. And so when you read that, you're like, yeah, they have a legal right. They can terminate. It's North Carolina's a right to work state. So anybody can terminate a agency agreement. But the key to it was, do they have the legal right to terminate? Meaning release themselves from the contractual capacity. So they could terminate the contract, but they can't release themselves from the obligation of that contract without the permission of the other party. So that's a lot of words, but that's what the essence of that question is. If you can get to that point, you're fine. Agency agreements are contracts, all right? And once we agree to it, we're bound to those terms unless the other party lets us go or if we complete the transaction. Okay.
Chris, one question.
Yeah.
So what if there is something that the buyer agreed and they are not actually following through? Then I have to like the buyer agent doesn't want to do business anymore because say there is discrimination, right? And they say, hey, I can't do business with you. Then I'll have to cancel the agreement, right? If I'm still held attached to it, I mean, how does it work there? So.
Yeah, let me tell you where you were going with that question. And then I'm also going to talk to you about a temptation not to drill down too deeply in these questions. So let's talk about what she said that is testable. Okay. What she said that is testable is, it sounds like to me she was describing an agent breach of duty. Am I in the right category on that?
I mean, it's something similar, but not that. It's just that the agent did not do it. Say, just an example, the buyer should not be discriminating by race, right?
Okay.
When they're trying, and they say they agree to it, they sign, but when we are showing houses, they seem to do it, and I'm not interested. I cancel the contract.
Okay.
But if I'm still tied to it, it's not going to work, right? So
Yeah.
because I don't
See,
want to do that. So yeah.
I would argue in that case that the agent is in breach of duty, and agents contracts can be terminated based on breach. The
Okay.
part I don't want to drill down into is you might have to go to court and stuff like that. But the simple answer to your question is, yeah, if the agent is not performing according to the contract or rule or law, they are in breach of contract and they can be fired for that person for that reason.
Okay.
Does that make sense?
Yeah. Thank you.
All right, Lisa, was that last one? Maybe I did write these because they say exactly what I'm saying. So Dun, 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 and at the podium, Bree got herself back up to third place there. She's feeling a little bit better. Y'all did well on the agency chapter, to be quite honest with you. For some reason, y'all are grasping that. And let me tell you what's good about that. First of all, we know on agency, you're going to get more questions on agency than you are most things. When you get an easy question on agency, take it, because there are a few that are easy, like universal versus special versus general. That's easy. What do you owe your clients? That's somewhat simple, although you have to read that closely to be sure. And then they're going to be the complicated questions that talk about not just what designated agency is, but when it's appropriate. When agency agreements have to be in writing. We're going to give you some tough scenarios about when agency agreements have to be in writing. Remember when I was with y'all on Monday or Wednesday, Monday, I talked about the idea of is oral dual agency ever possible? That's a tough question. We might ask you things like that. So if you can get a bunch of points in the agency chapter, it helps you on some of those other like license law that you're not getting as many questions correct on.